Hello, and welcome to the Identity Paradox Inside the Racial Pharmacon, a podcast examining anti-racist theories and practices aimed at dismantling destructive identitarian politics and ideologies, both in the US and abroad. Please note that discussions deal with very difficult subject matter, so every episode comes with a general content warning.
And I'm your host, Carlos Gallego, Associate Professor of English, as well as both Distinguished Teaching Professor in the Humanities here at St. Olaf College. This podcast is part of the programming brought to you by the Bolt Chair Endowment, so special thanks to the Bolt family for making this programming possible. If you enjoyed today's podcast, make sure to subscribe for future episodes. And now, the show.
Hello and welcome from downtown Minneapolis. This is the Identity Paradox. I'm your host, Carlos Gallego. And before I introduce today's guest and topic, I just want to say something briefly about potential background noise you might be hearing. The city has torn up the crosswalk across from the apartment building where I live and covered it up with giant metal plates that function like metal drums at night, especially when pickup trucks are driving over them at 60 miles per hour, which the city doesn't really care about because I called and asked, and they don't even know that the construction is taking place. So just a brief note for those of you that don't live in urban areas, especially in what are considered commercial/residential downtown areas, the city cares little about your sleep health. And so I apologize for any background noise. It's going on all night and all day. Luckily, the Thanksgiving holiday break. I don't know if it counts as Thanksgiving anymore. I think it's now the Black Friday break. As soon as Thanksgiving is over, it's like a Black Friday weekend. So hopefully the shoppers are not out about and they're doing a lot of cyber shopping. But if you do hear the background noise, I apologize for that. Today's guest is Stephen Grigsby. He is an attorney. He got his law degree from Georgetown Law School, where he went on to practice as an assistant district attorney with in Brooklyn with the prosecutor's office there. So he has some prosecutorial, I believe I pronounced that correctly, experience. And then he moved to Minnesota. As those of us that move from out of state to Minnesota find that we need to adapt. So Stephen went ahead and did his version of that. And for the last 23 years has been practicing criminal defense law here in the state of Minnesota. Is that correct, Stephen? Did I get that accurate?
Yes, you did. Thank you.
And thank you for joining us today. I invited Stephen because I know him personally, and I find him to be a very intelligent individual overall. And he's one of the few lawyers that I know in the state of Minnesota, but I know that he's more than qualified to speak about today's general episode topic, which is, I would say, the U.S. legal system and its relationship to things like race, racism, and potentially totalitarian fascist vigilante politics. And I'm, of course, talking about the three major cases that came to a conclusion in the last 2 weeks. The civil lawsuit in Charlottesville over the Unite the Right rally that took place in 2017 that resulted in the death of Heather Heyer. The Ahmaud Arbery case that just got finally resolved in Georgia, where Arbery was pursued and shot dead by 3 white men who found his mere presence in their suburban area to be enough of a threat to warrant lethal force. And we'll talk about the details around that briefly. And then finally, the most recent case, I believe the most recent, or at least one of the case that is gaining the most attention, especially politically across the US right now, is the Kyle Rittenhouse case, where Rittenhouse, who shot and killed 2 men, injuring a third in Kenosha, Wisconsin, was found not guilty on all counts of murder, including other charges like weapons charges. So we'll talk about the nuances of those 3 cases because I'm having a hard time being as optimistic as some people are being regarding the verdicts around these 3 cases or pessimistic along lines that have less to do with the law, the legal system in the United States, and more to do with the politics surrounding the legal system in the United States. And more importantly, and I'm sharing this with Stephen, the main topic for me today is essentially, is the legal system working? President Biden was very quick to come out publicly after the Rittenhouse verdict and tell the United States that the legal system is working, and no further protests are needed along those lines. And so I want to examine the, shall we say, accuracy of President Biden's statement that the legal system in this country is working. So along those lines, I'd like to start, if you don't mind, Stephen, talking about Charlottesville, which is a civil lawsuit, which is different from a criminal case. If I'm just going to give a brief background for our listeners or viewers, the jury in this case found that white nationalists and white supremacists engaged in conspiracy to intimidate, harass, and harm in advance of the deadly Unite the Right rally in Charlottesville in 2017. Among the guilty parties are Richard Spencer, who coined the term alt-right, Jason Kessler, who organized the rally, and Christopher Cantwell, who is popularly known as the crying Nazi, who's actually a violent thug in real life and a misogynist, but nevertheless is now known as a crying Nazi because he famously recorded himself crying because there was a search warrant for his arrest, and he was afraid that the cops were going to shoot and kill him, but they did not, of course, because he's Christopher Cantwell, and they don't seem to shoot at those kind of people. The jury awarded $500,000 in punitive damages against all 12 defendants and $1 million against 5 white nationalist organizations on the conspiracy count, for a total of over $26 million in damages. So the jury's verdict has been celebrated as a victory against racists and fascists, and I'm not completely disagreeing with that viewpoint. I'm simply curbing my own enthusiasm by questioning why this had to be a civil suit victory as opposed to a criminal one. And on that note, I just want to highlight the fact that the jury was deadlocked and could not reach a verdict on 2 federal conspiracy charges. I believe they're known as the Kkk Law, that date back to the late 19th century. The jury could not agree on 2 federal conspiracy counts. One, whether the defendants had engaged in a conspiracy to commit racial violence, and whether the defendants knew of such a conspiracy and failed to prevent it. Both counts are based on federal civil rights law, and the jury informed the judge that they did not think they could reach a unanimous verdict on either count of federal conspiracy. So it seems that the only reason Charlottesville and the verdict around that awful Unite the Right rally was a victory is because it happened in the state of Virginia. So the defendants in this case were found guilty and are now, basically responsible for over $26 million in penalties owed to the plaintiffs, only because this happened in Virginia. And so they were able to apply Virginia law, which to me seems like a loophole because it happened in that state. Had it happened in another state, we may not be celebrating a victory over the white nationalists and fascists that organized the Unite the Right rally. So, and that's the federal conspiracy charge that the jury themselves confessed they could not reach an agreement on. And my understanding is that there's going to be a retrial and they're going to bring the defendants back to court to retry them on those 2 federal conspiracy charges. So, Stephen, my first question regarding this is that I know that a federal conspiracy charge, it's my understanding at least, that a federal conspiracy charge requires evidence that is beyond all reasonable doubt, whereas a civil suit only requires a preponderance of the evidence. So my first question is, why and how does a preponderance of evidence not qualify as beyond all reasonable doubt? What's the difference between a preponderance of evidence and evidence that is beyond all reasonable doubt?
It seems like it may be self-evident, but it's really not. The first reason is that beyond all reasonable doubt is used only in those things where there is an irrevocable dimension of your humanity that can be revoked by the government, imprisonment. Has become since 1970 constitutionally mandated in any criminal trial where any liberty is at stake. Preponderance of the evidence reflects simply the fact that there are 2 equal people who wish to settle a dispute in court. The one with more evidence wins. The alternative term for preponderance is simply the greater weight, and it means exactly that, literally. Any greater weight, the party wins. So, but then the question, of course, is what does proof beyond a reasonable doubt? And I have argued this in probably 100 jury trials in some way. And the truth is that there isn't any precise calculus as to the greater weight. Even if you accept that in formulating the greater weight, there's people are mediating their experience with their own subjective account of their experience. So there is a dimension of incalculability to it, but it just beyond a reasonable doubt, I argue ultimately is simply that kind of proof that you would need. This is the court's instruction, but this is the essence of the argument. There is no better one than the kind of proof you would need to act with great confidence in the most important of affairs. That's what it means. What percentage? I don't think it translates into a percentage. But anyway, that's sort of the background between the two. A civil suit merely asks for a judgment, a monetary judgment, and a criminal suit asks for imprisonment by definition.
So I'm just curious, as in terms of the conspiracy charges, it seems like the jury was more comfortable with the Virginia law and very obviously deadlocked and split as far as the federal conspiracy charges. Does the evidence does federal conspiracy civil lawsuit require more evidence simply because it's federal? And so the jury was able to realize that through Virginia law, they could apply those statutes and find the defendants guilty, but only based on the state law and not the federal law?
No, I mean, unless there is something unique to that particular charge of conspiracy, as it differs between the two jurisdictions you mentioned, no, there wouldn't be anything unusual. Let me can you repeat just the last part of your question again?
Yeah, I was just wondering why it is easier to find the defendants guilty under Virginia law than federal law, if it's the same, in many cases, the same counts, the same conspiracy charges.
Correct. Well, yes. So there would be a difference in elements between the two. There would not be a difference in the amount of evidence that either side would require. Federal and does not imply anything more than it simply is a legitimate enactment of a power that Congress has to articulate a law. It doesn't mean anything more than that. The fact that it seems sort of more severe and serious is mainly because it has limited jurisdiction. It has fewer matters, and they also have a disproportionate national consequence. But no, there's no difference. So the difference in the jury would have been found then between the ease of proof of the different elements between the two jurisdictions' case law.
So basically the jury said we could find them guilty with preponderance, but we can't agree that we can find them guilty in terms of beyond reasonable doubt.
Only in a criminal case would proof beyond a reasonable doubt required. In whether it's a federal conspiracy charge or a state conspiracy civil charge, it would still be the preponderance.
Okay.
So because this wasn't a criminal case, it's a civil case. That is the universal standard in all Anglo-American jurisdictions for precise reasons with respect to equality before the law.
Okay. So then I'm going to switch it a little bit from the civil to criminal, because we know that the criminal charges were filed against James Alex Fields Jr. for murdering Heather Heyer using his vehicle as a weapon. Those were the only criminal charges, is my understanding, that were brought forth at the United Right rally. And no criminal conspiracy charges were brought against any of the organizers. It took these defendants filing a civil lawsuit in order to call attention to the fact that there was an organized conspiracy here to engage in essentially a hateful rally that was meant to instigate violence against people that, as the chants themselves said, were not white in any kind of nationalist or identitarian way. So my question is, or my concern is, that since it's a civil lawsuit and it's basically a monetary punishment that is being, dished out to the defendants in this case, I'm concerned that one of the messages that could be sent is that if you're interested in engaging in a similar type of rally and event and don't have any monetary wealth to risk, because if you do get sued, there's nothing they can take from you, that the only avenue available to pursue organizers and leaders that kind of manufacture these events, if you will, through chats and through, private conversations essentially, and make it public in the way that the Tiki Torch rally was very public and the events that ensued thereafter were very public. A lot of this is private. It's organized behind the scenes. They know what they're doing. This came up in court as a preponderance of evidence. And yet there are no criminal charges against those individuals. It's purely monetary. So is it possible that this could be sending a message to people who are not afraid of being sued because they have no financial wealth to risk, that they can engage in these types of public acts without any necessarily criminal consequence?
I mean, the simple answer is absolutely. This is the purpose of not criminalizing what you just described. Now, it may not merely be a function of pragmatism about sending a message. There are constitutional limitations about what kind of behavior can be criminalized, and particularly becomes acute with respect to openly political speech. So there's very, in other words, a federal statute would have a very hard time proving anything other than a simple criminal conspiracy without any ideological content. And the argument that you just recited really makes the ideological content central to the mechanism of causation. It originates in hate somewhere outside the jurisdiction. It mobilizes and marshals a bunch of people and concentrates them for the purpose of engaging in, agitated, boisterous conduct, and foreseeably somebody dies. That describes a civil suit, foreseeably. In a criminal case, you'd have to show they conspired to drive somebody over, that they planned it, that they without doing that, you run afoul of constitutional limitations. But there's no question it sends exactly that message, that if you do this, you'll simply face a probably uncollectible judgment.
And by just to clarify, by uncollectible judgment, you're talking about going after people and suing them for money that they don't have, essentially.
Correct. I can't remember which president it was when he was informed that the Supreme Court has issued an order that prevented him from doing something he wanted to do. He says, "I don't care, make them enforce it." So the whole point is the court doesn't enforce it. The court just gives somebody a piece of paper that they can hang on their wall and says that you owe them something. That's it. The court is limited to issuing an order.
So just as someone who's well-versed in the law, do you think that the Charlottesville verdict is a victory politically, or is it a moral victory in terms of there's some way that you can go after people like at least Richard Spencer, who we know does have money?
I think it is utterly empty.
Care to elaborate?
I don't think it has any meaning whatsoever. A civil suit in this is literally, without any kind of ideological dressing up, a dispute about a debt. That's it. This is not interesting material. The fact that it involved death and something else, that's one thing. But the idea, the more sinister element of even civil suits, why it's not a victory, is because you've essentially bought a human life. You've paid for it.
Yeah,
and you said we've had a fair exchange. The system works.
Justice has been achieved.
Right. As Biden would say, the system worked.
The system works.
You lost a life and you had some money. Why would you complain about this?
Yeah. And which is why corporations can get away with this kind of stuff, because people die at their hands all the time. And as people, they can't be held liable or criminally liable, but you can sue them for money, but they're not going to prison.
Oh, but far worse than that, they're the ones that have lobbied to create the laws that give civil penalties to all the damage that they do.
Right. Yeah. with no criminal consequence. And you're right. I mean, that's the thing that upsets me about this being an empty gesture. And I agree with you. This is a glorified version of the People's Court around an extremely dangerous ideological divide that is taking over the country at this point. And no one wants to address that in terms of criminality. We keep addressing it in terms of its morality and its ethics and its appropriateness, but we don't, it's very few people are coming out and calling it, this should be held criminally accountable. I think that's what's happening around the January 6th investigation. That's taking a long time, but I think, as Dave Newart, my previous guest, put it, they're taking their time because they want to make sure they have all their their I's dotted and T's crossed, because bringing these charges against these groups like the Oath Keepers and the Proud Boys and some of the major, in some cases, politicians that were involved with the organizing around the J6 storming of the Capitol, those will be criminal, and we might see some sedition charges against some of these groups, in addition to things like conspiracy and potentially even treason.
I mean, that's entirely possible, but I think that there's a lesson to be, told here about what we expect of a society that resolves its disputes with courts almost exclusively as the remedy, and not only disputes, but treating real life situations as if they were merely disputes over money. I don't think that. I mean, oftentimes, one's inclination is to say, there's some dangerous things happen, let's criminalize it. That expands our bureaucracy, and it expands an extraordinarily unmasterable power in the office of the prosecutor and the institution of accusation. And it doesn't solve a lot of problems, even if you think you have the right laws in place and you've been careful and inclusive. You end up enlarging the power of the prosecutor, and that is has the same authoritarian problems as the thing that they describe that happened in Charlottesville.
I can see that. So you have to be careful with the laws that you want to implement in order to go after your opponents, because those same laws can come back and be used against you.
Correct, because they're expressed in the abstract. They're expressed as principles. Somebody who does this, regardless of the circumstances, is guilty. And it ignores the actual position from which people act in our society.
Which in many ways is allowing politicians and pundits right now to create a false equivalency between fascists that are organizing things like the Unite the Right rally and anti-fascists who are trying to fight those people, and politicians basically saying both sides are anarchists and violent, protesters, et cetera, and extremists, and basically are just two sides of the same coin, when in reality, a lot of people that have been mobilized to be anti-fascist are doing it in order to keep things like the KKK from resurfacing in their communities. And that is being discussed as being equally extremist in the same spirit of Charlottesville and what happened there.
Yeah. I think the important lesson is that the attempt to simply expand the jurisdiction of things that suddenly become criminal can only be done in such blunt terms that they really have no particular target. They're just simply the instruments of the people whose election cycle has put them in charge.
And I know we're not, at least I'm not an expert in this, but I know that laws in other countries that self-identify as democratic like ours have different laws. For example, in Germany, freedom of speech is controlled there in order to disallow the reemergence of Nazism. For example, you cannot give a kind of Third Reich Nazi salute, because that is criminalized. That is considered that political ideology is considered basically criminal in places like Germany. Therefore, you cannot publicly promote that ideology and not be found criminally guilty of associating yourself with that ideology. It's not a joke. It's not a meme. It's not for lulz. It is dangerous, and then it's considered dangerous. Do you consider that to be extremist in the case of Germany?
Well, I mean, I with France, Holocaust denial is actually a crime too, and I looked at that, and I see what it is. It's an attempt to sort of have it both ways. Here we have freedom of speech, égalité, liberté, fraternité, and they simply will not permit freedom of speech. They have no justifiable reason for it. If in fact, if freedom of speech is the most important thing, then even fascism is toleration of fascism is worth that freedom. But they don't do it that way, and they try to have it both ways because they would be logically required not to. They would be logically required to regulate a lot more than speech if they went about this fairly. They would regulate the conditions that give rise to that kind of ideology, because let's face it, it's not real ideology. No adult, mature mind grasps that with any kind of acuity or rigor at all. It is not ideology, it's performativity. It is an act. It is like yelling fire. All it does is signal to other people membership in the group. It's perfect. There's a perfectly good reason to ban it. But you can't talk about freedom of speech and all those principles that are related to the economic mechanisms of society. You can't have it both ways. And unfortunately, that's what Germany does. And they say, well, you know, in the case of the Holocaust, you should understand us. We had a very, a direct role, and we are responsible. And so you can excuse us. No, I can excuse that, but I can't excuse then the balance of your principles that aren't that. Anyway, that's my take on it.
No, it's very interesting because I think it applies equally to this country. And it's a reason why we're having a lot of the debates we're having around free speech, because you're right, we want to have it both ways. We want to silence certain versions of speech and promote others, and then still claim that we have this almost absolutist freedom of speech, which we never did have an absolute freedom of speech, which is why you can't say bomb at the airport. And we don't talk about the social contract and the sacrifices that it requires to be a part of society in terms of some of your freedoms are going to have to be sacrificed in exchange for the supposed security and safety and order that you're supposed to receive in exchange for the sacrifice of those freedoms, or at least certain freedoms.
Do you know, by the way, in what kind of case that the majority of, at least in Minnesota, precedential cases about freedom of speech have come up in? What would you guess?
I would say religious.
Not at all. In disorderly conduct charge. The disorderly conduct statute was used throughout the 60s because it says you can't engage in obscene, lewd, and behavior like that upsets people. And so somebody finally appealed this, and it was a young girl that was accused of giving the cop the finger, and the cop arrested her, and they had to torture the statute. So what they did is they left the statute as it was, but said, let us judges understand what this really means, is that this is an exception we're making here. And the statute doesn't really mean that. It means that you can give the finger, but we'll keep the other vague language in there. And the result is they arrest thousands of innocent people for an unconstitutional retention of language. And then the courts say, yes, oh, hey, it doesn't mean that. We said that last time. Wow. But that's how it's used. And it's still that way as we speak today. And police are still arresting people for precisely those unconstitutional reasons. Now, that's one issue. Second issue is that they've had a chance to talk about saying bomb in the airport and other things. They have limited now disorderly conduct when it's any speech at all to a performative, they call fighting words. It's not a very good term because it doesn't really define, but fighting words has to be an act. When I raise my fist to somebody, I'm not saying anything except communicating the intent to fight. It's an act in itself through its very performance. So they've limited it to that. But the police are still arresting people for the most part for all those other reasons which are unconstitutional. But anyway, this may finish this last point. The fundamental point is that they have narrowed it from all of that superfluous language down to the only speech is one that by its utterance performs an act.
Interesting. So they're basically assuming that there has to be some intentionality behind the speech. There has to be some semblance of an act to be performed, or it is in and of itself an act. It's not what you say, it's how you say it.
It is you simply remove the semantic content. You simply treat it like an act. And if somebody enacts it volubly through their vocal cords, then we assess, what did this do? Is it the signal? Is it a signal as a call to arms to threaten an attack? Does it endanger people by signaling emergency leave in a fire? There's no truth, underlying empirical truth. It's a signal. That's why it's an act. Any speech, contrarily, that has any intelligibility to it, you're allowed to express.
Okay, that's interesting. So that sounds like it's pretty absolute in terms of freedom of speech to some degree. I mean,
correct. But the Court of Appeals in parochial jurisdictions like Minnesota simply don't have enough experience with these issues. I remember one of my first appeals was a disorderly conduct where my client had called a referee at his son's soccer game an asshole in public, and they arrested him. And he came to me after he had been convicted representing himself, and I appealed it. And I argued that this was simply obscene. It was lewd, but it wasn't a crime. It's vulgar, but this is not manners. This is something that the content of which has to immediately endanger or impair somebody. And as I was doing it, the Harvard-educated Court of Appeals judge, Bruce Willis, named after the actor, well, a few years older, he said to me in the middle of it, "Mr. Grigsby, the court is aware of the content of your client's remarks. Would you please stop repeating them in this court?" And rebuked me for the overuse. And I said, "Yeah, I'm going to lose now," and I did.
Because you said the word asshole way too much in the courtroom, right? Basically.
Well, it's just that the ultimate issue is that if it's that clear what's going on, this is what's going on. The courts simply are not intelligent.
Well, that's kind of what I'm getting to. It's hard for me to imagine what the performative act behind calling someone an asshole is, what the potential risk and dangers of calling someone that are, right? I mean,
it's simply a faulty, logically faulty opinion that cannot be reconciled with binding superior precedent.
Except in the Mary Tyler Moore state. The Mary Tyler Moore state does not like profanity, and therefore it is criminalized in certain cases, right?
Right, and I can tell you that this man was extremely fastidious, because he liked to remind people that the pronunciation of the English word ERR from error is not err, but He insisted on these stupid things like that.
That's interesting, because that's going to come up, I think, in the third case that we'll discuss. But just to move the discussion ahead to the Ahmaud Arbery case, that one's very interesting. And just to give, again, listeners and viewers a sense of what we're talking about in terms of background, this week, literally, Travis McMichael, age 35, Greg McMichael, his father, age 65, and their neighbor, William Rhodey Bryan, age 52, were all found guilty of felony murder in their unwarranted pursuit and subsequent shooting of Arbery, a 25-year-old Black man who was basically guilty of jogging in a white suburban area where these three white men found Arbery's presence to constitute a threat and acted upon it with lethal force. Travis McMichael was also convicted of malice murder or intent to kill, and all three are still face federal hate crime charges and will probably receive life in prison, potentially without parole. Now, what I found troubling is that this murder initially went without any national attention. I remember this is being celebrated right now, especially in the South. It's like, oh, the South finally has woken up to justice. The South finally got it right. I've read column and opinion after opinion about how important this verdict is. Now, what I find interesting is that if it wasn't for the actual ineptitude and stupidity of the defendants and their attorney, no criminal charges would have been brought up against this racist trio of would-be murderers. The police let them walk free, and prosecutors didn't press charges at the start. In fact, one prosecutor, Jackie Johnson, has been indicted and is facing charges of shielding the suspects from the shooting and from the actual crime. The prosecutor that took over the case, Waycross District Attorney George Barnhill, justified the use of force in that incident as a lawful citizen's arrest in a letter to police. The system at this juncture in this story is not working, to go back to President Biden's statement. So just to reiterate, no one was initially charged until 74 days after the murder, and arrests were finally made mostly as a response to national outrage emerging from a local radio station's release of footage showing the murderous pursuit, actual footage of the pursuit and the shooting, which was ironically submitted to this local radio station by Greg McMichael, one of the defendants, and his attorney, who is right now not available for comment. They submitted this footage to the radio station in their minds to exonerate, to basically address any potential lingering doubts that people might have had about their supposed innocence. Had these morons not tried to absolve themselves in the court of public opinion by releasing this tape, charges would never have been brought against them. National outrage would not have emerged. Because the police were not cooperating with local journalists releasing information, and the prosecutors were shielding the suspects. So this case seemed painfully obvious as another example of racist vigilantism in the tradition of George Zimmerman's murder of Trayvon Martin. However, despite this obviousness, it took the stupidity of the actual suspects and their idiotic attorneys' willingness to self-incriminate them that resulted in justice being pursued. Again, it seems that the victory was the result of extraordinary circumstances more than the normal functioning of our legal system. The system seemed intent on preventing any justice from being realized to the point of criminal cover-ups by the actual prosecutors assigned to the case. The glaring irony, again, is that despite the seemingly systemic cover-up, the jury needed only 2 days, I think 2.5 days, to reach its verdict. So to the jury, it was painfully obvious. Apparently to the prosecutors and to police and everybody that was involved at the case, in the case at the time and investigated it, and found no crime to have been committed. So despite the verdict, my enthusiasm remains checked. So my first question, Stephen, is the verdict a product of bizarre circumstances or the result of the system working, as President Biden is saying?
Well, I mean, those two things are not necessarily opposed to one another for the system to work. I don't even mean that humorously. There are many odd things that happen that lead to a criminal trial, more than you would imagine. Things that just you only would have been aware of in movies at times. Now, in my personal trials, it hasn't been that interesting because I'm not a public defender, but I have friends that are. But anyway, this is routine to have unusual circumstances that accompany a lot of trials, and the system has a way of dealing with them for right or for wrong. I don't believe it often gets it right, and I mean simply not that there ought to be different rules, but I don't think that they're honest in their application of the existing rules. But let me just address finally Biden. This is what presidents say anytime there's a verdict, because it's a constitutional guarantee, and absent some obvious visible evidence of corruption or anomaly. I mean, what can anybody say? This is what any good democratic citizen of the United States should say. Absent any notion of tampering or perversion of the system, the juries have a right to do whatever they like.
But in order to counter that, Stephen, I would say that the system didn't work. And that's painfully obvious. It took 74 days to bring charges against these three men, and that would have never happened had they not willfully submitted that footage to that local radio station, which went national. And then people across the nation were so outraged at the obviousness of what they saw on video, just like the Rodney King case decades ago, that, or in more recently, the murder of George Floyd, that it was the national outrage that literally and motivated or forced the prosecutors to reinvestigate the case. And it was so corrupt and it was so dysfunctional that prosecutors that were in charge initially of the case are now being indicted themselves for covering it up. So how can we say that the system is working just because the verdict emerged as guilty, but there was obvious police and prosecutorial cover up and shielding of the suspects prior to that.
Well, assuming all that is true, there was in the end a guilty verdict for precisely what they did. And it was not really disputed, and it was not, as you correctly state, particularly difficult to arrive at. So the system did work. Now, none of that is true if one of your premises is correct, that nothing but a inexplicable manifestation of this video by a defendant and his lawyer, which appeared to me to be the sole evidence on which anybody was going to rely on a verdict. I didn't see it, but I heard witnesses, and I did follow the trial, and I heard summaries on the news. And when I read the verdict and I heard their defenses and their cross-examinations, it was clear, I could deduce from that the video was damning, and there was no way around certain things. And then the guy testified, the guy who is alleged to have asked for favors from the former DA. And I could tell by his testimony, he was desperate, and there was nothing else for him to say, except to hope that the good old boy network would listen to him as a soldier that went down for their cause in some way that's plausible to utter in contemporary society. That's what I saw. And I was certain it was going to be a guilty verdict on all of them. I had some doubts about the one guy who can't remember who he was. He wasn't the father. He was the other defendant. I can't remember his name, but I thought he would be acquitted potentially, and he had been acquitted of some of the charges. And when the verdict was read on him, I realized that they had believed he had used his car to corner and restrict Ahmaud Arbery's escape. I didn't see that, but I'm assuming that is the only thing that video could have showed.
Yeah, it was damning evidence, and had that video never been submitted, those men would have never been charged with murder.
Now, if that's true, you're 100% right. But it would be a dispute between you and Biden about whether or not you can, make that extrapolation.
Fair enough. I think that the preponderance of evidence would be on my side to say that a guilty verdict in and of itself is not the beginning and the end of a legal investigation, and that we need to pay attention to the totality of how that verdict came to take place, including the police investigation and the police's role in either covering it up or in offering the evidence that led to the guilty verdict. And in this case, the police were not cooperating, and neither were the prosecutors. It's almost like the court of public opinion forced them to actually do their jobs. That's what I would argue.
Well, I mean, that is all true. But that is also part of the system, isn't it?
I would say,
let me say, we elect judges, we elect prosecutors, and so the public voice matters to judges and prosecutors. And because the judiciary has one role in society that includes public opinion and a serious exercise of power in the franchise for their offices, that's part of the system working.
Again, yes, I would agree with that, but I would say that the term system is a very generous term in this case, because system would include the people that were in charge of investigating and bringing forth those charges, and it should not require a spectacle of outrage at the national level in order to bring charges against 3 men who shot and killed someone who was jogging around in their neighborhood. And just to bring charges to see if they're guilty. It shouldn't take the spectacle of a national outrage in order to make that happen. That should be the result of police investigation and prosecutorial agreement with whatever evidence the police bring forth. I mean, that to me is the system working. What happened in this case is not the system working. It is an extraordinary accumulation of circumstances. And I hear what you're saying. Every case has that to some degree, but this would have never happened as a current example of racial progress happening within our legal system. To me, it speaks to the contrary. It speaks to the fact that we still have people that are so racist they're literally willing to cover up murderers to allow them to escape if they kill the right body.
Well, I mean, you're right. The system is meant to do the exact opposite of what you described accurately about a failure of a dimension of the system. And I have no investment in the term system and its scope, but except to advocate for Biden's position that we understand that when we create institutions and we elect people who have faults. And there are ways of dealing with people's faults, including the one that you just described that happened in this case. And sometimes it does take, as a final safeguard, public opinion to be outraged. It's a considered an integrated part of how the system is intended to work. And in this case, it appropriately influenced what appeared to be really what. Let me put it this way. It appeared to be a lynching, is what I was going to say. And I mean that much more seriously than one may think. I don't mean it as a metaphor. Nobody lynches anymore because the artifacts of lynching are just simply no longer socially relevant. We live in a gun culture.
Just to add to your argument, though, President Biden himself, before he was President Biden, called it a lynching himself. When he saw the video, he go, that's a lynching. That's just, yes, that's a public lynching.
He didn't know enough about it to mean it in the way that I mean it.
Right. No.
And I mean it very specifically. Their defense was citizen's arrest. And it was the citizen's arrest power that arose out of the fugitive slave hunting. Right. And then when slavery left, it was these people who were suddenly, there were militias that would go around, and the Kkk and other populist racist groups developed from that. But that became part of the laws of states for precisely that reason. And they were used. When I saw that defense, it occurred to me that they were clearly guilty. They could not coordinate their racism with video evidence of the modern day. They mishandled it. I think when they sent that out, they just assumed there would be more sympathy for the good old boys trying to do the good old right thing that nobody accepts anymore. But when I saw that, this is what I mean. They counted on that privilege to root out Black people with long, dirty toenails from their neighborhoods.
And that's exactly what I was about to say. They even relied on the oldest of arguments in terms of criminalizing the body itself as unclean and therefore threatening just by its mere presence. In this case,
that's just the long toenail reminds the jury he's a different race.
Yeah, exactly. Okay, so just pivoting off of that, because I think it's interconnected, is the Kyle Rittenhouse trial that just ended in Wisconsin, and that's the one that Biden came out and spoke publicly in favor of the verdict and in favor of the system working, regardless of whether people found it to be just. And I know this case depended a lot on the prosecution's need to demonstrate that Rittenhouse did not act in reasonable self-defense, which is a really high bar. All in Wisconsin, if you say that you did what you did because you felt that your life was threatened, then it's up to the prosecution to prove that your use of lethal force did not constitute reasonable self-defense, which is difficult to prove. And I've been reading from various prosecutors and say, yeah, that's a really high bar to me. Now, nevertheless, I think that there were plenty of factors in this case that make it seem like Rittenhouse did qualify for a felony murder charge based on the fact that he crossed state lines from Illinois to Wisconsin. He lives really close to the border, but nevertheless, he crossed state lines to instigate a confrontation with protesters as a self-identified counter-protester, and that he owned a gun illegally at that time. He was too young to purchase the AR-15. I think a friend of his bought the rifle for him using a stimulus check, of all things, which just goes to show how our government works in this country. So, and moreover, there was evidence of plenty of bias, of violent intentions towards BLM protesters, like chats that Rittenhouse had with friends of his as he was watching people loot a specific store. He said in a chat that he wished he had his AR-15 or had an AR-15 because he would shoot the looters, which again shows violent intent, as well as other violent confrontations that he had with women and stuff in his background that the judge in this case, Judge Bruce Schroeder found to be irrelevant to this specific case, even though the prosecution was trying to say that this spoke to the mindset that Rittenhouse had when he arrived at the scene, that it was not just accidental, that he had some kind of intention for going to Kenosha on that night. For many people, including legal experts across the political spectrum on both sides, right and left, the non-guilty verdict was not shocking in and of itself. But the reasoning and the after effects are considered disconcerting nevertheless to many people. In this case, there is no enthusiasm to curb because he was found not guilty. So I'm kind of more confused and angry as to the reasoning behind the non-guilty verdict. It seems that the verdict has more to do with politics and justice, particularly the politics around the Second Amendment in the state of Wisconsin. It seems that in states like Wisconsin, you can carry a firearm to a public event, you can instigate a confrontation, and then kill someone while claiming self-defense, which is what Rittenhouse essentially did. Can you explain the logic behind this legal argument? Because I don't understand it.
It's very simple.
Sorry.
It's very simple. A person may exercise any right or perform any act that is not prohibited, even if they're motivated with the hope that they may end up killing a Black person over it.
Wow.
That is, they are allowed to do that. And I can tell you in this case, the politics here happened in charging a person who was clearly under any straightforward third-year law student bar level exam question, not guilty of an assault. When I started watching the trial and I saw the defense cross-examine willing witnesses, I knew there was simply no way anybody was going to convict him. The evidence was overwhelming that you can despise Kyle Rittenhouse, but if you accept, as the jury would have been required to accept, that if he had a legal right to defend himself under the circumstances, and those circumstances appeared to justify it, even if you don't like the political currents that brought them into contact with one another, it was clear. This was not a difficult case. It was charged solely to appease a political constituency.
So you don't think any charges should have been brought against Rittenhouse in the first place?
There were none to bring. The one charge that they brought, the misdemeanor charge, got dismissed on what's called judgment of acquittal, that the judge listened to the evidence after the close of the state's case and said, even if everything that even if the jury believes everything you say is true, you don't meet the elements of a crime. There were no charges to be brought. And by the way, let us remember, this is the same thing that happened in the Freddie Gray case in Baltimore. Marilyn Mosby immediately charged a bunch of police officers with no evidence whatsoever. And there were no convictions. There was one hung jury on the bizarre theory that he gave a rough ride to somebody with the hope that he would kill somebody. It was nonsense. And he had a hung jury. And he was the first tried. Everybody else was either acquitted or their cases were dismissed. That's what happens when you try to import politics into a system that operates according to non-political rules.
Now, I think the political rules that are influencing the legal system here, though, are based around this notion of gun rights and this emerging philosophy of you can instigate a confrontation, literally, and then shoot someone and kill them and claim self-defense, even though you went to that specific location in order to initiate a confrontation.
Yes, but you cannot initiate a confrontation and kill somebody in self-defense. One of the instructions a court would give would be that a person who was the aggressor has no right to self-defense. And by the way, that was something that they used in the other case we just talked about, Ahmaud Arbery, that they were convicted because they had no right for self-defense because they were the initial aggressors. Kyle Rittenhouse, it was clear to me from the cross-examinations that there were ideological squabbles in which Kyle Rittenhouse ran away from, no matter how much you despise whether or not ideologically he provoked them, but he ran away. And from that moment on, he was besieged until one was injured and two were dead. That's the evidence of this case. None of this was disputed.
No, none of this was disputed, which brings me to some of the politics that happened inside of the courtroom. So there were some bizarre moments that many people say could have influenced the verdict, although, as you state, and many legal experts have stated, this was going to be a very difficult case to win for the prosecution because of the self-defense laws in Wisconsin. But it seems to be like there were politics that were playing out in the courtroom, and that Bruce Schroeder's behavior from like allowing Rittenhouse to be an actual actor in the theater of the case itself by allowing him to pull the names out of the tumbler to exclude certain jurors, which is highly unusual. Usually you ask a clerk, a court clerk, or the judge does them themselves, or a member of the jury, but you don't usually ask the defendant to participate in those type of practices inside of the courtroom during their own trial, because then it could frame the defendant in a different light. And also the fact that the judge dismissed the gun possession charge, right? The fact that he used essentially what are, outdated hunting laws in order to excuse a 17-year-old illegally possessing an assault rifle or an AR-15, it's called a long handgun in the state of Minnesota, and taking that to a protest. That was the charge that you were talking about, the misdemeanor charge that was dismissed by the judge, and that was his personal call.
No, it was not his personal call. Well, let me say that it can be. A judge has to give no reason why he dismisses any account. He at that point can say, if for any reason, without having to disclose it, I find the defendant not guilty of everything, and walk away from the bench, and it's as good as the jury did it. That's not why he did it here. There was simply a want of proof. The gun, in order to be illegal, had to be a certain length.
Yeah.
And I saw this discussion, and it wasn't, and there's nothing you can do about that.
Right.
If this is why we have measurements, because so nobody can be made guilty of having the wrong measurement or a compliant one.
And I understand that, but it was a stretch because at the time that he purchased it, he was underage, and they basically had to interpret the law as if though he was a son out hunting with his father. That's the only reason that law exists.
It may be, but it does not matter. His lawyer, I would have been derelict and kicked myself in the butt for not relying on a law that exonerates my client of a charge.
I'm not disagreeing with the validity of the defense. I'm just trying to highlight the judge's role in all of this, and to say that as a judge who's up for re-election, it seems that he played an active role in bringing in Kyle less as a defendant and more as an actor or agent in their own case. And
first of all, you're right to call it exactly what you did. That is a fair characterization, the sort of the bizarreness of it. That does not happen. And when it does happen, it happens for the state, not for the defendant. This was a very, very unusual. I bet you almost no defense lawyer can count one case or maybe two cases where they got any kind of help from the judge because of an affectionate relationship to the image of the defendant. No, this was, I mean, here's the problem though. I'm a defense lawyer. If the judge starts behaving that way to the state openly, I get a mistrial, I get a reversed on appeal. I can appeal everything. The state can't.
Right.
The state can only appeal they have to show that this court's ruling, what this court was doing, they can't ask for a mistrial. They can, but they have to show this court's ruling warrants a mistrial, and the higher courts are reluctant to do that when a judge is presiding over. Anyway, but yes, I have never in my life seen a judge go so far as to, the worst offense is not even the one that you mentioned, was to, in front of the jury, ask the witness to give character evidence about himself before he testified, and then insisted to the jury that he be applauded for that. Even if it was past performance, that issue could not have been raised by the state. And so the judge brought it in, and I have no idea whether the man intended it or not. It makes no matter. That was something that was enormously helpful, the benefit of which I have never received in my career as a defense lawyer.
And so that kind of brings me back to the notion that the legal system is working, because for me, that could possibly qualify as the good old boys club way of trying to treat a young good old boy.
Sure, well, it clearly was. And I understood exactly what the reasons is. This is an old man from a generation in Wisconsin that had colleagues in the Klan down there. This is who he is. Nobody would go out of their way in a controversial case on television to show that kind of extraordinary favoritism to a defendant in his courtroom. Judges are terrified of doing that because everybody's supposed to be afraid of the defendant. And if the judge, and the other point is this, the judges are normally not willing to be that nice to a defendant because it offends the representative of the people who elected him. When a judge grants a defense objection, he's ruling against the representative of his voters themselves.
Yep. And it seems like, yeah, this judge was more attentive to his constituents than he was to the actual, let's say, the proper protocols of how a case should be handled in the courtroom.
I can almost assure you, if you talk to lawyers who have tried cases in front of him where he had defendants he despised, he probably did a lot of similar things, but more muttering and under his breath until they were convicted, and then he can have his day at sentencing. I know this judge was a clown. He reminded me of the Minnesota judges that I've appeared in front of who are from this jurisdiction. You know, Minnesota doesn't import really smart cosmopolitan people. They import people who inherited wealth from land and then got the education and that can trace their name back several generations. This is who our judges are in Minnesota.
Wow, that is definitely an old school way of granting people power. Let's just say almost aristocratic, like pulling a sword out of a rock, but having your parents help you do it. All right. So the thing that bothered me about this case, Stephen, is the optics. This is the last thing I want to talk about. So Rittenhouse was found not guilty. There was an immediate GOP celebration around this because many conservatives were in agreement that he never should have been brought to trial. Former President Trump famously said he should have never faced this. He should have never even been in a courtroom in the first place. So now he is the poster boy for Black Lives Matter counter protesting. He's a poster boy for gun rights. He's a poster boy for outright vigilantism, which is what the three men in Georgia were found guilty of in the Arbery case, right? Since his trial ended, Rittenhouse has appeared on the Tucker Carlson show, where Tucker Carlson reaffirmed or affirmed the fact that Rittenhouse is a nice young man, basically wanted to reinforce that character trait in Rittenhouse. He was invited to Mar-a-Lago by former President Trump, where he was again congratulated and told that he was a very nice young man who did never wrong and never should have gone through a trial in the first place. In other words, no crime was committed there. And Representative Marjorie Taylor Greene is now wanting to put forth a bill that would award Rittenhouse a Congressional Gold Medal. All of this seems to counter the supposed justice achieved in the previous two cases, in my opinion, in terms of the progress that the system has achieved so far in terms of racial justice or political justice in general, and the ramifications of those cases. In other words, the system is working. I understand that in terms of the letter of the law and in terms of whether or not Rittenhouse committed a crime upon being attacked, I hear what you're saying, and I understand the legalities around that. What I think people are not paying attention to are some of the things that we just, or some people are paying attention to or debating, are some of the things we talked about: the judge's behavior, the way it's framed, the way it might be connected to traditions around these jurisdictions and some of these places. But what concerns me is that the message is now, you can not only not only can you show up to an event armed to the teeth with an AR-15 and other weapons, if they're legal, you can instigate a confrontation so long as you're not the aggressor, but you can force someone into engaging into a confrontation. And as soon as that person gets physical with you, you can shoot them dead and claim self-defense, even though you traveled miles to go to an event that you knew was already heated with the intention of instigating and escalating the situation to the point of physical confrontation so that you can find an excuse to kill somebody, especially if you are a right-wing extremist, who tend to be the people that follow that kind of playbook. Do you agree or disagree that this could be one of the not invisible, but kind of like these dog whistles, these messages that are communicated underneath the headlines in between?
But let's be clear that Black Lives Matter got what it asked for. It got a prosecution. It has no right to a verdict. This is the difference between politics and the judiciary. There is no way you can televise a complete ignorance of the Constitution and the rules. So what happened is they forced the prosecution, and they got exactly the hero that Trump, and for the reasons Trump says, he should not have been charged. You cannot simply abuse the system to satisfy a political desideratum. And the evidence was this was a terrible political decision to charge him, because it has made the right credible that this is what the left will do. And they're right in this instance. They're right in that instance. Don't use the justice system and verdicts to enforce a political agenda. It doesn't work. I don't mean it doesn't work in the sense that it's dishonest. It literally won't work. You will not get from it. The decision to charge him was improvident. There was no way to circumvent the rules that would prevent the jury from finding that out and acquitting them.
So my question would be, do you think that what essentially ended up protecting Rittenhouse in this case was the way that the laws are written regarding self-defense in states like Wisconsin, or would this have probably been the case in other states like, I don't know, California?
I don't think it would have mattered. Let me say this. I've done about 100 jury trials. That's a rough estimate. Never counted after a certain number, but I'm close to that. And I say that because an assault is a standard part of any private criminal defense lawyer's fee base. You get a lot of assaults. And I've tried lots of cases. The only count of any criminal case that I have won in every single instance I have tried it is assault. And I don't know for sure, but I would guess in every single case, my defense was self-defense. Self-defense, and this is an ancient as the last name Grigsby, probably the 14th century, an old law, and it reflects ordinary, easily understandable, enduring social principles. You have a right to defend yourself. And it's very simply this, is that when you have any evidences at all of self-defense, it can be a single question or a blur in a photo in which you're willing to make an argument, this is the key to self-defense, then the state must disprove it beyond a reasonable doubt. Now, in any case, assault or anything else, proof beyond a reasonable doubt is meant to be high enough to let many otherwise completely guilty people walk away. It is designed to simply make convicting innocent people impossible. It concedes. Let's assume that I can tell you this: 97% of all the cases charged result in convictions, either most by plea, other by trial. Okay, that doesn't mean that there are as many trial not guilties as guilty. We don't know anything about it. 97, so virtually they get it right. In my own experience, I have almost never encountered somebody that I believed was totally innocent. In the one instance I was certain of it, the prosecutor was also convinced and dismissed. Okay, that is the system, and that is my experience of the system. Now, in most cases, I do not feel my clients have gotten a fair trial. And this is the danger of the system, that the judge in Wisconsin would have acted to the exact opposite. effect in these cases. And when politics can be used used instrumentally, or to make an instrument of the justice system, we don't have whatever break the justice system, whatever independence it had, is lost, and it becomes a pure instrument of who won the last election. This is a dangerous power. It is more. We're not going to hear from the people in Charlottesville anymore. This power is enlarging as we speak. I just tried 2 cases in Hennepin County post Derek Chauvin, and this is anecdotal, but I got a very, very strong sense that the institution of accusation, its eminence has been enhanced in the minds of the public, because they believe the system worked when it plucked that one murderer out of a host of murderers and said, "See, we're fair." And so now that power, if it's more efficient, if its honesty is enhanced, that is going to be used disproportionately against Black people who are going to jail. That's how it's going to be used. And it's going to, because Black people occupy the numerically largest number of overrepresented people in the system. It's not exclusively Blacks, but that could vanish, and it could be somebody else in that place. And that's the problem. And this is not being remedied here. In fact, people are complaining about the verdict as opposed to understanding the judiciary has no power for social change. It just doesn't have that power. It can regulate the status quo.
And so if I may, then some people would argue that the status quo is already so racist that if it had been a Black defendant carrying an AR-15 in that situation in Wisconsin, they probably would have been shot dead by police officers. Or had the crowd that stormed the Capitol on January 6th been a crowd of Black and brown bodies, there's no way they would have been able to breach it the way that this one crowd on January 6th did, because at the end of the day, race still plays a role in the courtroom, whether it's lawful or not.
That's correct, because white people don't have the appearance of an entire subclass of people that they, an appearance that they share with the subclass. So it doesn't matter when the majority of people who look like you are poor and historical victims of racism. It becomes a matter of simple navigational rationality to simply be aware of the appearance, because it may, in that case, represent a probability of something else. So it makes it rational to be racist. The problem is not to use the courts to say we convict, that we now want to treat Kyle Rittenhouse as we've historically mistreated Black people. The point is not to mistreat people, and so it's not to sort of bemoan that Kyle Rittenhouse got away. It's that some people are being accused disproportionately and suffering disproportionately, and that's because you have to you remedy the underlying social matters, and that's why when BLM insists on prosecution, I don't trust them I don't trust that they've understood the issue.
I understand what you're saying. So in order for the law to change, if we want justice over the laws that exist right now, it's going to happen socially first and then be legislated after the fact. It's never going to take place vice versa. In other words, the law will reform itself without any social pressure, is what you're saying.
Well, I mean, listen, how one does it, I have no idea. I will punt to Adorno, who says exactly that. I have no idea.
Yeah.
I am able to analyze what simply exists before me. And to finally quote Marx is that I can be certain of utopia. I can be certain of it because I know for sure it is not this.
Yeah, that was about to say. And as far as legal utopias, regardless of the verdicts that happened in the last couple of weeks, I would say this is not it.
In the right world, I don't believe the criminal justice system would be the first recourse to a rational social organization. It seems to me to simply be a displacement of a lot of issues that are primarily about access to the world's resources. It's as simple as that. If there wasn't that initial dispute, there wouldn't be a legal system to settle subsets of that dispute.
Absolutely. Private property and its discontents.
Yeah, this is the system. Even the socialist Black Lives Matter would have been perfectly happy about a guilty verdict for Rittenhouse, period, simply because they wrote it.
In your argument, go ahead.
No, I said for that reason alone, that they wrote it, they would have been happy with putting a man in prison for the rest of his life.
And what you're saying is that regardless of how we may feel politically and ideologically about Rittenhouse and his motivations for being there that night in Kenosha, what you're saying is that we cannot manipulate the law to fit our own political agendas, because at the end of the day, that manipulation of the law could come back to haunt your own side or you yourself personally.
There is that pragmatic reason for not doing it. The other thing is that the legal system serves a different master and has a different purpose than what it's being invested with. The verdicts are not totemic. If you understood what they were and how they occur and have been through the boring, relatively bureaucratic procedure that produces them, without much fanfare and a lot of just boring, redundant, repetitious material, you would understand what was going to happen in this trial from the beginning.
Yeah, and
that
makes sense.
People don't understand it. That's all. I get that. I wasn't always a lawyer. I mean, in fact, I wasn't even a guy who wanted to be a lawyer. So I wasn't one of these guys who sort of like, oh, I kind of like legal shows and I like legal issues. I had no interest at all. I had Robert Crowley's opinion of lawyers, you know, from, I don't know if you saw Downton Abbey, but Robert Crowley is an aristocrat, and by a stroke of bad luck, his fortune goes to a lawyer, and he can't believe a man works every day. Anyway, that's what I felt. But I am a lawyer, and I simply know when you are honest and rigorous about the system itself, you realize you have very little control over anything, that it's the law and the facts that control. And I'm telling you, it is almost impossible to change the law and the facts, except in minor tinkering that pleases a lobbying constituency here or there.
So Enlightenment society, just to stick with Adorno for a little bit, Enlightenment society punted the questions and problems of justice and ethics into a legal system that is now basically a bureaucracy that functions around the notion of private property.
Yeah, that's exactly right. That's exactly what I meant to say. That it is exactly as you said it.
Wow. Well, that's uplifting. At least
somehow, to amplify that, somehow justice is limited to a verdict that either involves putting a person in a cage, which has a checkered history and actual history, to revive that as a functioning, laudable destination for people who are guilty of an injustice. This is insane. Yeah. But it's the system that's there, and we as individuals, including myself, who has tried to fight it in various ways over the years, I have absolutely not influenced it. I have not changed it. The verdicts I have obtained are largely the result of chance and luck. And if I am honest with what I have done in my life, that I have made caging human beings seem socially acceptable. By providing a social service to the courts.
That is one of the most honest job descriptions I've ever heard from an attorney. I just want to congratulate you on being one of the.
If I'm an attorney, I'm not insane. I simply look back on what has happened. When you're young, you know, and bad things are happening, then some good things will happen, and you misunderstand it because you think that you're playing a major role in this. But I can tell you, after a very difficult retrial of a drunk driving double homicide up in Brainerd, Minnesota, in which the evidence favored me because of a very unusual revelation in court. The reconstructing witness for the state had made an error, and I knew it had been an error because my witness told me. And so I cross-examined him from his own book, and he read the contrary opinion from his book, and he said, yeah, you're right. Maybe it didn't happen like I said. Anyway, the point I'm trying to make is I gave just this robust closing argument that the state is a conceding doubt. And then they came back hung 6-6 the second time. They were hung the first time, hung this time, but it was getting closer to acquittal. And I asked the jury foreperson afterwards, you know, about what happened. And I just remember asking the question, did anything I say in closing argument assist the jury? And he said, very politely, he was a very polite guy. He said, I'm sorry, what did you say in closing argument? So I realized I had been superfluous. And they had talked, listen, he told me they talked about things that they were forbidden from talking about, like, is this guy a good guy? Does he really contribute to society? They told me this, and I know how it works. And that's also a sense of powerless because you can't really count on them. So the only thing you can do is humbly ask them. This is all you can do as a lawyer, is to humbly ask a jury to simply perform the duty as they understand it from my argument, prosecutor's argument, and the court's instructions.
That's why every jury should be required to watch 12 Angry Men before they become jurors. That's just a cultural studies argument. Apparently you don't like that movie. Okay, sorry.
You also have to remember, I don't like these movies in which innocent people get acquitted after, suffering a lot of misfortune, which brings me to one point you made before, is that the acquittal is going to encourage people to do what Kyle Rittenhouse did. And I assure you, nobody wants to make that argument at the cost of their life to a jury. Absolutely nobody. Nobody is doing things for which you can be charged with first-degree murder. They're parading him around as a hero because nobody will ever repeat that ever again. That will never happen. It's the worst thing in the world to be guilty and convicted. We understand, you committed the crime. You still don't want to go to prison. You still suffer more. That doesn't go away. You don't say to yourself, yeah, I have it coming, I'm okay with it. That doesn't happen. But to have to go through that, and if he didn't have the funding of a bunch of racist supporters, he may not have, or he may have. That almost looked like the case the local drunk public defender could have won. But it was several $1 million. And I could tell you, when he testified, I knew right away he had been prepared appropriately. I don't mean to. His attorneys did a very, very good job, as they're supposed to. There was nothing about them that you really noticed. There's no personality. There was no controversy. There were no loud objections. They had a theory. They were sticking to the game plan. They didn't deviate from it. And they knew they were going to win. Yeah. They weren't baited into anything. Yeah. And then they found out that now they had a judge who was going to give them anything they asked for that he could credibly say to an audience.
Yeah. Well, I will venture the most despicable of bets and say that I do believe this is going to inspire other people. Mass shooters usually, not that this was a mass shooting, but mass shooters really don't need inspiration. Rittenhouse was already a t-shirt prior to the verdict. I believe that this is going to amplify the heroism behind this vigilantism, in the sense of people showing up to events armed to the teeth and not afraid to engage in confrontations anymore because they know they can use their weapons freely after the Rittenhouse trial.
Yes, I mean, and let's assume that there is far more plausible evidence for the outcome. And I'll even go so far as to say, let's assume, just for purposes of my argument, that it's a certainty people will imitate that. That is not something the legal system is able to do anything about. So what should we do?
Gun laws.
So what should we do? Have the judge convict people who aren't guilty under the law just to prevent that? Make a sacrifice of a person? That's what they're asking for.
No, I think this is what motivates Congress to go re-examine gun laws in the United States. Because what this is essentially saying is that if it's almost encouraging people to go buy guns.
It is. Everybody's going to want one now.
Exactly.
It's like, hey, you believe that I can cross state lines and shoot 3 BLM protesters? Yeah, no, but that is why he's a hero. He's mobilized people. And by the way, let's not forget, it's because political pressure forced the prosecution. That pressure did whatever negative consequence you're talking about here, BLM caused it.
Wow, that's a controversial stance to take, Stephen, but I see exactly what you're saying, and I'm not sure I disagree with you, because what you're saying essentially is that by turning it into a spectacle of so-called justice, what they did is that they reinforced the fact that the law is on Kyle's side and always will be, regardless if it's Kyle or someone else.
I mean it even much more humbly than that, is that he was charged on evidence that was not of a crime. There was no probable cause. Once you listen, I was shocked that the entire thing was on video. Every single second, you knew where everybody was very precisely. No one disputed what happened. once a jury is properly instructed on reasonable doubt and self-defense, there is no other rational conclusion. The Court of Appeals would have acquitted him had that been the case. It just simply was wrong. And this is what people don't understand. That was a political act to charge him. That was the political act that was totally unnecessary that caused him to be a hero.
And it strategically backfired, is what you're saying.
Absolutely. I don't know. I don't know if it backfired. I think to a certain extent that supposes, they're not just groping and they don't know what they're doing. I mean, it's just blind groping, this political pressure.
Fair enough.
But
okay.
But the main thing is that this ought to be far more disturbing when an institution caves in like that and wants to pervert the law for an unelected, dark money source of publicity. Anybody could fulfill that function, and that's what you do when you allow political connections to the legal system. Now, I'm not naive enough to not be aware that there are already many, but these are the forces that corrupt the system. All of them.
Well, Stephen, you've given me, and I'm sure listeners and viewers, plenty to think about and to mull over regarding the differences between the law and what we perceive to be as justice or just. It sounds like we still have some work to do as a society on that front. Any final thoughts that you'd like to share with viewers and listeners, Stephen, or anything you'd like to tell them about yourself? Maybe Adorno Talks is coming back. I'm not sure.
What about Adorno? I caught that at the very end there.
Is the podcast coming back at any time, or
no? Here's the thing. I'm not bringing it back. It wasn't that interesting to most of the viewers. It was interesting to me because I got to interview, especially the first guy. You want
to describe first what we're talking about, because most people are like,
I have a Facebook page called Adorno Studies. It over about 10 years. It's got about 5,500 members, and we have lively discussions about Adorno. And I've gotten to know real Adorno scholars who are on there, and non-Adorno scholars who are also very, very bright and very smart about a variety of issues. But anyway, I just decided to see if I could make it interesting, and I did a couple of podcasts. I interviewed one person with whom I'd had a public kind of a polemical dispute. But it's a podcast, and he probably thought I was going to be mean, but he was willing to do it anyway. But I wasn't, and he was a pleasure. He was a pleasure. He was wrong, just like I thought, but he was a pleasure. And then there was a discussion that occurred in which I did another podcast, and I had enough experience at this point to ask that it be Stuart Walton. He always gave the most sober, perfect remarks about everything all the time, in anything that he ever said. And I interviewed him, and he was exactly that way. He answered questions just through his recitation of texts that I'm intimately familiar with, that summarized them in a way that I wasn't able to summarize them. And he sort of solved a lot of riddles for me. And he's really the best exegete of Adorno that I've ever heard. By the way, he wrote a book long after I was out of college, which had it been available, I wouldn't have taken me 20 years.
What was the book called?
I can't remember what it is. His name is Stuart Walton. He is the clearest, most accurate student of Adorno I know. And it's interesting because he came at Adorno through Samuel Beckett. He was interested in Beckett, and Adorno had a lot to say about Beckett.
Yes.
And then he became
Notes on Literature, in case you're interested, listeners and viewers. Notes on Literature, Volume 1, I believe Adorno has a couple of essays on Beckett in there.
Oh, but he talks about Beckett everywhere.
Yeah.
His aesthetic theory was going to be dedicated to Beckett, and they knew each other in real life. And in fact, Beckett openly disputed Adorno's claim about an artifact or a prop in one of his plays.
Oh,
and they knew each other, and there was this. One was the true artist who didn't care about philosophy, and one was the philosopher who cared about art. And I don't think Beckett could understand or wouldn't concede to Adorno the pertinence of philosophy to a work of art anyway. But it was a fruitful disagreement. But he came at Adorno through Beckett, and he understands that dimension of Adorno, that sort of almost sober, tragic. There's no strong affective dimension to Adorno's writing. There's an aphoristic intelligence to it, and that suffices as sufficient beauty to state the truth as accurately as possible about the matter he's talking about.
Yeah.
Anyway,
Minimum moralia. That's how you get to that kind of perspective, right? Very honest.
But this guy, Stuart Walton, he was the clearest. And after him, it was almost like there was nothing that was unilluminated in Adorno for me, because I had solved the last couple of riddles to what I understand now as just a very clear system.
Fantastic. So we'll probably have to bring you back to discuss some of that stuff, and maybe bring back some of those chats from the Facebook conversations you had around that general theme. Well,
I don't know if they're appropriate, because I was often informal and nasty to people. Sorry.
Well, thankfully you weren't nasty today, and you were a pleasure to have on. The very informative, very knowledgeable takes on some controversial verdicts that have taken place in the last couple of weeks across the U.S. Thank you for your insights on the legal system, and thank you for educating us as to why these verdicts were correct, or at least following the letter of the law as it's written. And also for informing us about why politics cannot be adjudicated in a courtroom necessarily, or you're not going to win based on your politics. You're going to win or lose according to what the law says.
You are welcome, Dr. Gallego.
Am I wrong on that summary, Stephen?
No, absolutely
okay.
Right.
Just wanted to double check. Well, thanks again for joining us. And again, I hope to have you in the future so we can talk some more Adorno specifically. And
very good. I look forward to it.
All right. Well, thank you, Stephen.
Bye-bye.
And that will do it for this episode of The Identity Paradox. Again, I learned a lot from our guest, Stephen Grigsby, and his takes on these three cases. I definitely understand now why certain verdicts came out the way they did, regardless of their ethical or ideological consequences. And I think that Stephen has given us plenty to think about in terms of society's responsibility to justice and our propensity to punt or to hand over that responsibility to a legal system that is in many ways accountable to us. So if we want justice in the world, we're the ones that are going to have to make it happen and not rely on a court system. So just more things to think about. Thank you for joining us in this episode of The Identity Paradox, and hope to see you next time. Bye.
Oh, and don't forget to please subscribe to future episodes if you enjoyed today's. Thanks.